Good evening, everyone. Welcome to today's Wisdom Circle session on inheritance planning. Wisdom Circle is a platform focused on helping seasoned professionals navigate work and well being in meaningful and future ready ways. Through initiatives like Curiosity Talks, we bring together experts, practitioners, and diverse voices to spark important conversations that help people prepare thoughtfully for the evolving phases of life and work. As seasoned professionals, many of us have spent decades building careers, creating assets, supporting families, and shaping legacies. Yet, one of the most important conversations often get postponed, and that is inheritance planning. Today's session is especially relevant because inheritance planning helps reduce uncertainty, prevent conflict, and ensure that our intentions are communicated thoughtfully and effectively. We are delighted to have Nikhil Varghese, co-founder and chief domain officer at Yellow, with us today to guide us through this important subject and help us better understand the practical, emotional, and strategic aspects of inheritance planning. Nikhil is a chartered accountant with 2 decades of experience in estate and inheritance planning. He has led this practice at leading firms such as EY, PwC, and 361 Wealth, where he served as regional head for South India. Over his career, Nikhil has advised families on protecting and transfer assets worth thousands of crores, making him one of India's foremost experts in this domain. Welcome to the session, Nikhil.
Thank you, everyone, and thanks for having us here. Yeah.
So, Nikhil, I thought we could start off, with this slide where we had asked our registrants to participate in a poll where they put in their responses. And what do you say about the results here?
No, so I'm not very surprised, very honestly, when I see this, right? And honestly, the number is pretty much in line with what we usually see, and given the kind of folks here, the age bracket I look at, this will broadly
Yeah.
sit in a way that I kind of can imagine. And unfortunately,
Okay.
that's the situation in India, right? As in, not many plan for this. We'll talk about all of these aspects subsequently. Yeah.
Sure. And then we had asked them one more question. What is your biggest concern when it comes to inheritance planning? And this was the result.
Yeah. So if you see this again, if you see the slide, pretty much aligned to all the how do I put this? Is basically some notions that are there, right? And the surprising or the conflicting part here is that the last aspect, which is family dispute, that kind of comes in very contradicting to the whole aspect here, right? Because you plan to avoid
Hmm.
family dispute, but unfortunately that becomes the reason why people don't want to do. That's again going
Right.
back to the thought of saying, let's, if we invoke this, will this create more disputes in the family? Instead, let me not do anything, right? That's the whole thought.
So let's just start off with what exactly is yellow and why
Sure.
did you start it?
No, so the whole purpose with which why we started Yellow, right? As in just going back to my background, I'll just give you that aspect as well. I was helping good number of HNIs, ultra HNIs, taking care of their estate planning requirements. Obviously, that's a great market for me to be in because you get good rewards for the work that you do. Small ticket, as in few people to manage, but high ticket items, right? But realize there's a huge gap in the country with respect to any of these hygiene with respect to estate planning. Creating a will is a basic stuff, right, around this. So that's something which we thought was a huge gap. And maybe why not address it, not in a traditional format where do this in a individual physical capacity, but combine that with tech so that a high quality, highly accessible tool is available to everyone basically democratizing the whole estate planning piece, right, for the Indian market. That's the whole intention with which we started. But I mean, while we kind of forayed in that direction, what we realized is that end of the day, while this is something which is a good to have situation, is what is there in everybody's mind, and that's something which is kind of getting reflected in the survey that you did as well, right? What is another major point of impact for, or a pain point for everyone, was the transfer of assets post demise. Basically, where to go, how to go, what documents to obtain. All of this became a great or a big pain point for people, right? And that's something which we knew is a big pain point. We thought, let's address it subsequently. Realize this is also something which is much more important for everyone. And we kind of brought both together, saying, let's do will for people during their lifetime to take care of their financial hygiene. And God forbid, loved ones pass away. If they need support with respect to transfer of assets pan India, we kind of put together a 360-degree solution, which is kind of covering the entire life cycle. That's the whole purpose with which we started Yellow. We had the domain expertise, team kind of working on this for quite some time. Plus, use the tech, leverage tech rather, to make this accessible and pocket friendly to everyone. That's the whole reason why we started Yellow.
Okay, and why is it critical in today's India that estate planning should be given importance?
See, again, since we're talking about it, this is something which will kind of raise some eyebrows here, right? If you see this number of 1,50,000 crores, this is the unclaimed assets lying in India, 2 years old data, right? Which is in bank account, insurance, various other financial institutions. And this number is beyond 2 lakh crores at this point in time when you're talking about today. And this assets, which is unclaimed assets, is growing at 20% return on a year-on-year basis for the government treasury, right? Now, why is this important? Is because when you pass away, families have no clue in terms of what assets your loved ones owned. When you don't have that information, it's very difficult to find out those assets by doing a Google search or whatnot, right? Information available is where you're able to track it and kind of say these are the assets available that we need to chase and make it available to the rest of the family. And that is something which is a huge gap. And if you don't plan for it, this becomes extremely critical. Second is that the litigation situation in the country is that more than 76% of litigations are related to property and family disputes. Again, going back to the fact that no planning being done, which is resulting in family disputes arising, and therefore it's also choking the judicial system today. Right? And the third aspect is that if you don't plan much, or rather if you don't plan, at bare minimum, again, there's an average timeline. It can go even higher, is about 3 years is what it takes for families to kind of recover all the, kind of undertake all the activities to receive what is rightfully yours, right? And therefore it becomes extremely important that you start planning. This is more from a numbers perspective. There's also the legality to it, right? But what does the legality talk about is essentially, you're talking about something called as intestate succession. Now, what does this mean? Is essentially to say that if you don't write a will, you fall within the definition of intestate succession, which would mean that your assets will be now distributed as per the parameters that the government has prescribed. Wherein for a Hindu male or Hindus, you fall under the Hindu Succession Act. For the others, you fall under the Indian Succession Act. All are close to 100-year-old legislations, not much amendments which has been undertaken. And basically, you fall within the broad parameters. But that's where it becomes very critical for everyone to start planning, right? And why those parameters are important to even look at is because, for example, if I have to take an example of an Hindu male, if you don't do anything, your assets get distributed between spouse, mother, and children equally. For Hindu female, it goes to spouse and children equally. God forbid spouse and children are not there, it goes to in-laws before it goes to your own parents, right? Again, for Christians, it's 2/3 to spouse, 1/3 to spouse, 2/3 to children. Muslims again have 1/3 is what can be willed. The rest has to go through personal laws unless you take an NOC. So there is complexity, and therefore it's important to understand. The other argument could be to say that Nikhil, how does it matter this exactly how I want the assets to be transferred? So why do I even need to plan? Government has given me a methodology in which assets has to be transferred. I'm comfortable with it, and therefore I won't do anything about it. Still, then, if you don't do anything about it, your family, though it has to go to spouse, mother, and children for a Hindu male, all of them need to prove that they are the legal heirs to you. How do you do that? Is you go to court, obtain various documentation such as a family tree, legal heir certificate, succession certificate, pedinama. It varies depending on which jurisdiction you are in, because each state have their own documentation that is needed. The nature of the asset also determines what kind of documents that you need to take. For instance, if I have to take an example of Karnataka, for immovable assets, you need to get a family tree, which is from the municipality. Now, if you go movable assets, it has to be from the court, which is called as a succession certificate. So you can't take a succession certificate and go transfer, immovable assets, and you can't use a family tree to go transfer a movable assets. Now, family tree, you will get it in 2 weeks at the most, right? Unless some complexity comes in. Now, succession certificate will take minimum 6 months through the court. And succession certificate also has a court fee, which is about 2 to 3% of the value of the asset. Good part is Bangalore at least, or Karnataka at least, caps it at 45,000. But other jurisdictions may not. For instance, Bombay caps it at 75,000, right? So these are things that is going to come in, which will mean that you're going to pay additional cost to get these certificates and then transfer the assets. Right? Therefore, you're also having a kind of a loss in the assets or monetary loss that you're incurring with respect to, recovery of the assets. And more importantly, the other aspect is that, the point that I spoke about earlier, right? Because you don't have visibility of what the assets are, there's a high possibility that some of your assets can join the unclaimed assets pool. And therefore, it becomes important that we start planning. I hope that gives a broad understanding of why this. I know it went a little long, but broadly covers why the importance of planning.
Yes, you covered quite a bit, Nikhil. Which brings me to a critical part about this planning, and that is the making of wills. And there are so many myths around wills. So, cost is one myth that many of our listeners themselves, in fact, if you see the messages going on in the chat, it's a myth that many of our listeners themselves have pointed that out. So, what are some other myths?
So the one basic myth, right? As in there are multiple myths around this, right? We'll cover 2-3 broad line items, right? One is that, all of us. Okay, let's ask this question in the poll also. If somebody, or rather in the chat, somebody wants to answer. How many of you believe that once you have done nomination, the nominee becomes the owner of the asset? Nominee is custodian. No, incorrect. Nominee only holds it for the heirs. This is a much more educated or aware, educated is the wrong terminology, aware crowd here.
Well, Nikhil, we are at that age, you see, so we have to be aware.
Yeah, but I see a few still saying that yes, nominee is the ultimate owner of the asset. But the point is, it's not, right? Like most of you have answered here, nominee is just a custodian trustee of the asset. The role of a nominee is to take the assets. Obviously, if you're a nominee, you'll get the access to the assets from the banks, financial institutions, and whatnot. Your role is to transfer the assets to the legal heirs. Now, how a legal heir is defined in India? Only 2 ways. Either you write a will and define who the legal heir is. If you don't write a will, then it's the Indian succession law that I spoke about earlier, defines who the legal heir is and they have to transfer. Automatically in our mind, what happens is that we feel that, hey, because I'm the nominee, I need to get access to these assets. I get it and I don't need to do anything about it. And obviously, if the others don't claim, obviously the money stays with you. But everybody else, all the legal heirs have a right to claim these assets from the nominee. That's the whole point here. Right. The second, myth could be to say that I need to write a will only when I'm very old or very sick, right? Again, why am I saying this as a myth? Because traditionally, that's how you kind of push this to the last minute. Again, what is the logic here? At least I can assume the logic to be that we all are trying to predict demise. I'm not going to die now. I'll die later. Probably before that, let me do not now. But life is very unpredictable, right? If life is so predictable, you don't even need to write a will. The previous day, just transfer the assets and move on, right? But we are planning for the uncertain scenarios, and therefore it becomes important that we start planning. One other myth, or rather, it's not a myth really, is that everybody feels that, registration of a will is mandatory, right? It is not. By law, it's optional. You don't need to register your will, but there are benefits for registering the will, which we can talk about it. But beyond that, there's also a concept of stamp duty. Should the will be on a stamp paper? Should it be notarized? Nothing needed, right? Those are myths. You don't need it to be on a stamp paper. It can be on a simple A4 sheet. You don't need it to be notarized. Again, you can notarize, no harm, but I actually, technically, I see zero value, right? Don't even go down that path because I'm not sure how much it's going to help. But at least registration has value, again, depending on what your objectives are and what your assets scenario is. If you have properties, it makes sense to register because transfer of properties through a registered will is much faster than an unregistered document. Because you don't want your beneficiaries to run pillar to post for doing this. It's a small cost to incur now, which will take care of, rather, it'll save a lot of trouble for your beneficiaries, right? But beyond that, if you think there's a possibility of litigation, etc., on your will, registration really helps because government now becomes a third witness. So disproving the will becomes a little bit more difficult. And another aspect of benefit of registration is that if you have lost your original will, you can go to the sub-registrar's office and take a certified copy. It's as good as an original document. And that's one other benefit of registering the will. These are some of the myths. Obviously, cost is another myth. Everybody says it's expensive. Obviously, platform like ours make it much more pocket friendly, but traditionally it has been expensive, right? Actually, another myth that I would like to talk about is that everybody feels that once I write a will, it's pretty much frozen. You can't do anything much. It's actually wrong. You can do any number of changes to your will after you write. Technically, every minute you can make a change to your will. Obviously, the good practice would be to say, let's start, at least read your will once in a year. If there's no substantial change, don't make a change. Nothing to be done, right? But if there's a change, obviously go back and amend your will. Another follow-up question that you could have there is that, how do I amend my will? Right? Do I hash this will and write a new will, or do I have an amendment, like a supplementary document, something called as a codicil? Both options work, but the moment your edits have gone way too much, it's better to, kind of ignore the past will and write a fresh will. It becomes much more easier for everyone to kind of follow it, right? And one other aspect, which is an add-on to this, is that everybody also feels that once I write a will, I'm losing control of my assets, which is not the case. The will actually comes into the picture on demise of if anyone, right? Until then, the assets are yours. You can do whatever you want with it. You want to sell it, you want to gift it, you want to give it to charity, anything that you want, you can do with the assets. Only on your demise is where the will comes into effect and gives direction in terms of how these assets needs to be transferred. These are broadly the myths I would like to cover. If others have any questions, happy to pick up those as well.
Hi.
Yes, Sanjay.
Go ahead, sir.
Yeah, just wanted to know the various, for example, apart from the immovable properties, for various FDs in the bank, if nomination is filled out, is that not sufficient, or I need to have again that included in the will? I mean, I don't have will. I have been thinking of getting my will done, but for last 2 years I have not been able to do it because of lack of.
Understood. No, fair question. As in FDs, etc. See, two points that you kind of highlighted, right? One is immovable assets. We'll talk about it in there also nomination.
Which is
but with respect to
nominated with different my
Sure.
children. So do they need to again include it? I mean, by default, they don't get the sum on my demise.
Yeah. So on demise, what happens, sir, is that obviously the nominee will receive the access to the assets, right? There's no two ways about it. If you have said, your child one is the nominee to this account, the child will actually receive the assets, right? No two ways about it. Now, the issue is not about is whether they can receive or not receive. Because from a bank's perspective, that's a clean transfer of assets for them. There's no questions from their perspective also, because the legislation also says if you discharge the money to the nominee, you can't be questioned further tomorrow on anything else that happens from their family dispute standpoint. But from a legal perspective, whoever is a nominee is only receiving this asset as a custodian. The role of that nominee is to transfer these assets among the legal heirs. So if your wish is that this particular asset only needs to go to one person or a combination of one or two people in whatever percentages, better to have a will along with it, so that they, as a nominee, they receive the money as well. But with the will, they make it very clear that they also not only a custodian now, they are also the legal heir to that property. If I'm giving clarity in terms of why will becomes important. No, but the law is very clear, sir.
Thanks,
nominee, nominee is that's a situation for a nominee. So it's better to have nomination plus will, so that it's very clear from your family standpoint.
So Nikhil, this is Anuradha.
Hi, Anuradha.
Hi. I visited your website because you were on Wisdom Circle earlier also.
Yeah.
I had a chat with your customer support. But tell me something. You are saying that the will is there's no relevance of registering a will unless it's
No. I said no
1 minute,
relevance for stamp duty and notarization. Registration, there is a relevance.
No, you just said that if a will is made and it's notarized, it's good enough. I understood that.
Sorry, I'll clarify it again. What I said is that there are three components to what I said, right? One is stamp paper on the will. Second is notarization, and the third is registration. Stamp duty is not required. Notarization is not much of relevance. Registration has its benefits.
Okay, so because I have already registered one will of mine, but the point is I want to revise the will, or let's say I want to make. I feel there are because there were some updates of transfer of property, later. So I wanted to now. I want to understand, because you see, you are expensive. You are not frugal, as you are saying. I found your rates quite expensive, because you are saying that just for reading a will, let's say will draft, what you mean, and suggesting on that you have some 3,000 rupees or something like that. And then you obviously, because that makes no relevance, because reading is hardly any relevance to me, because I may make a will which is in a language format, etc. I may do a good job. And, because there is a previous will. And and then you, for New Delhi, your customer support said charging registration 10,000 to begin with. So I really don't know, because how much are you costing like, suppose I have a will which is, not suppose, I do have a will which is registered, but some points need to be changed and some additions need to be done. So I want to understand, being in New Delhi, I want to understand when I can do a formatting on my own, why am I going to pay so much money to your organization?
So, ma'am, two points that you highlighted, right? Now, when I said our offering is not very expensive, we are using tech to make it inexpensive, right? Which would mean that you're drafting the will with your comfort, at the comfort of your home, right? But what you're asking for now is to make it traditional. Basically, get a lawyer to review your document, right? That's human element coming into the picture. Obviously, there's going to be a cost to it, right? Because there is going to be a human element cost that's going to add. That's the reviewing cost that we spoke about. Second is that registration. Registration has nothing to do with Yellow, ma'am. It's the cost that the sub-registrar agents is going to charge. There's no mandate that we need to do this. You can do it on your own, and you'll see the cost is going to be the same.
Hey, Nikhil. Nikhil, yes. Anurag, can you hear me?
Yeah, I can hear you.
So I just want to go back to that point about, will versus nomination. I get the difference. Now, if I were to draft a bill, I can do it in a very static way where I say, okay, this particular savings account needs to go to this particular person and so on and so forth, right? Correct. Which is a very static will and prone to change. And whenever it changes, I need to amend the will.
Correct.
Or I could say that I've defined my nominations to reflect the inheritors that I want to, leave my assets to. And therefore, the nominee is also the inheritor, and I put that line in the will. Now, if I do that in the will, is that legally acceptable?
It's legally acceptable. There's no harm in it, right? But typically what happens is that when you look at something on these lines, then are you listing out your assets, right? That becomes important. If you're not, then are you giving details of these assets to your family as well? Now, your question is more in terms of saying this becomes extremely static that I may not be able to amend, or rather, for me to amend, I have to go back and amend the will as well. You need to go back to the basics of how much dynamism that you can bring even with this same approach, right? Now, if I look at bank account, the balances keep shifting, but asset is going to the same person. If you're taking the pain of updating nomination, you can update the change of who it should go to also, and that's one point. Now, when it comes to demat account or any other investment accounts, you don't need to talk about your mutual fund holding fully, every list of mutual funds. You don't need to talk about all your shares that you're holding. You can talk at a high level, right? When I say at a high level, the level above, which is your account that is holding these assets, be it a wealth management account or your demat account, where you can say all the underlying assets will be distributed in so and so fashion, which automatically takes care of all the changes that's happening below those accounts in terms of reshuffling your mutual funds, change in your trading, your stocks, and so on and so forth. All of those will be still dynamic, but still you will receive, your families will still have clear clarity in terms of who gets what from that particular account itself. I hope that's also making sense.
So let me summarize my understanding of what he just said. If I make a one-line will saying my nominee is also the inheritor, you're saying that is legally acceptable, but that is not a comprehensive transmission communication document.
Correct.
And I therefore have to have another way of letting my inheritor know as to what am I leaving behind. Because if I don't, that poor guy will be out in the cold wondering what exactly is it that he's inheriting.
Yes, absolutely right.
Okay, understood. Thank you.
Yeah, Nikhil, I just want to know, suppose I have a will which is registered and I have 3 properties. And subsequent to the registration of the will, one of the properties I sold off and acquired one new property.
Right.
Now, what do I need to do? Do I need to get the will registered again or whatever? That's my question. Thank you.
See, technically, you could have had an addendum or a codicil to it and taken care of. But I'll address your question also. Maybe I'll address this for others also, so that two scenarios get addressed. Let's look at your scenario. You've sold and acquired a new asset. In your case, I would say it's better to get a new will done and register it as well, so that property transfer becomes easier. Now, you could have another scenario where you sold the property, but you didn't acquire anything else, right? No new property. In that case, I would say you don't need to do anything at all, because your asset which is gone is out of your estate pool. Your will continues to be valid no matter you've actually captured those details of the asset which you have sold. You don't need to amend a will just because you've sold an asset.
Yeah. Hi, Nikhil. I just want to check. What is how and where do you register the will?
Sub-registrar's office, right? There's no jurisdiction. You can register your will anywhere in India. But typically, when you go for registration, they will ask for saying, what is your address and so on and so forth. Typically, the questions that will come our way is that, is this a property, where the property is there, should I register? Or where I'm staying, I should register? There's nothing really that you need to do. Wherever you are, whether you're in the location where the property is, or where you're actually residing currently, or in a third jurisdiction, is absolutely fine.
Thank you.
But it's at the sub-registrar's office.
Yes. Thank you, madam. Sir, Mr. Nikhil Varghese.
Yes,
you have started explaining the will part. Unfortunately, the completion has not over and people have started with some knowledge. So what I request is, please complete your seminar and who will be asking you questions. Only my question was, is a witness must if it is written on plain paper? If a will is
it
given?
is must, sir. Sir, for the law says there are these things to be mandatory for you to make your will valid, right? Okay. One is you need to be a major, that is above 18 years of age.
Right.
Second, you need to be of sound mind when you are writing the will.
Right.
Third, you need to have witnesses
Okay.
At least minimum 2 witnesses. You can have more than 2, but minimum 2, right? And the fourth thing is that you need to sign your will with wet signatures, which is mean that you can't do digital signature. You have to sign it manually, and the witness should be witnessing the fact that you're signing this will, which is very important. You can't have a witness saying that today Nikhil is signing it in Bangalore, my witness is sitting in Chennai. It doesn't work.
All right, got it.
The witness has to witness you signing this will, but the good part is that the witness need not know the content of your will. They just need to testify before the court tomorrow, if this comes into the picture, that I've seen Nikhil sign this will in front of me. That's all is their role.
Even plain paper also, with this witness is a must. That's it. Thank you.
My question was, in the remaining session, are you going to cover and guide us how to prepare a good will, especially for retired? Retired from service.
We can cover it. I'll do it right away. Sure. So I'm going to share one slide now. I think it'll help everyone. Is that this is a checklist for a robust will, right? One, like I said, you need to have declaration by the testator saying that I'm doing this out of my own free will. Nobody's forcing me to do this. You need to also have a list of assets and liabilities so that people know what exactly to chase, right? Because like earlier what we spoke about, you can have a single one-pager will saying that all my assets goes to my spouse. Is it a legally valid document? The answer is yes, but is it effective? Probably not. Right? So you can have a list of all your assets and liabilities to say this is how my asset needs to be distributed. It becomes a legally valid document. Third is that you need to appoint beneficiaries. Obviously, you're saying we're writing a will, which is mean to say that I need to give direction in terms of how my asset needs to be distributed. Right? In that exercise, obviously you need to say who is receiving these assets, and therefore appointment of beneficiaries become important. And to take this one notch better, what you could perhaps do is also to say that what if my beneficiary is not there? Today, if Nikhil were to write a will to say all my assets goes to my spouse, God forbid if Nikhil's spouse is not around or they passed away in quick succession, your will becomes redundant because you're saying it only goes to my spouse. So therefore, you can go the next level to plan for contingency to say if Nikhil's spouse is not there, this is how the asset needs to be distributed. That will make the will much more robust. Also, you can talk about, the aspect that we spoke about earlier in terms of making it dynamic. You could also have a residuary clause to say that if I've missed out any assets or if I acquire assets in the future, this is how I want the assets to be transferred. That makes the will robust. Obviously, if the change is substantial, it becomes important that you amend. Otherwise, you can continue with this as well, as long as, that's good to go with, right? These are some of the aspects that you could do with respect to contingency planning with respect to beneficiaries. The other aspect is that you need to have an executor to your will. Who is an executor? Basically, the person who's going to give effect to your wishes. Today, if I say all my assets goes to my spouse, somebody on my behalf when I'm not there has to give effect. And that's the role of an executor. You should appoint an executor. If you don't, the court will mandate you to appoint an executor. The idea of doing all of this is that you don't go to court. So therefore, you appoint an executor and also plan for backups there. That's a good practice to have because life is uncertain. Your executor may not be around. Executor may not be willing to take up this role, or executor, for whatever reason, is not able to do this, right? In that, if you have backup, the next in line can also take up that role. The other aspect is that we spoke about witness. You need to have minimum 2 witnesses and, signatures. That also something I spoke about. Should be wet signature, no digital signatures. 2 other things that I want to cover here, which is good to have, aspects in addition to.
When you say appointment of beneficiaries, appointment of executor, it means we have to mention names of those people as executor, as beneficiaries, right?
Yes.
And secondly, for liabilities also, we have to mention the names. Who is going to take care of?
So the way we look at liabilities is what the law says, sir, is that even if you have clearly mentioned who the beneficiary to their assets are, the law says unless all your liabilities are met, assets should not go to your beneficiaries. Okay. So therefore, having a list of liabilities helps. Now, why is this important is because there have been situations where suddenly people pop up saying that I was supposed to receive X amount. So if you have a list, you can say at least this is what has been communicated to us, right? When these are hand loans, etc., where there's no evidence, this will kind of help. Otherwise, also it helps you in clearly knowing what are your liabilities so that as an executor, the person who's distributing knows what all needs to be set off before, assets are transferred to all the beneficiaries.
Okay, please continue.
I think somebody else had a question for this slide itself.
The question was, thank you for this great presentation. And the question was, can the executor be a beneficiary?
Yes, absolutely fine, no problem. Thanks for asking this point. Executor can be a beneficiary and can be an independent person as well. No harm, you can do both, right? But witness should not be a beneficiary.
But is it essential that executor should be an advocate or any common man can be there?
Any person, right? See, what practically happens, sir, is that executor, while appointing an executor, end of the day, if they're not able to do this on their own, they'll obviously appoint advisors, professionals to get this done. And that power they will always have, right? So therefore, executor need not be a person professional to do this. You can have a professional executor, but not a mandatory requirement, right? Typically, if I were to say, in my case, I'll give you my example, right? In my will, I've said all my assets goes to my spouse. And my spouse is also the executor. Because she's the one who's going to receive the assets, she might as well be the executor and close things out for herself, right? But if you have a complex family, where it's a large family, wishes are very complex, assets going to multiple people, there having an independent executor will actually do a better job.
But suppose the executor is not stated as a beneficiary under the will. Can the executor kind of challenge the will and ask to be a beneficiary?
If the executor is not a beneficiary in the will?
Yeah.
I didn't get your question.
So there is an executor, say one member of the family is the executor, and another member is a complete beneficiary. So the executor is not a beneficiary under the will. Can the executor challenge the will in some ways and say, even I'm also a beneficiary?
So
while he is actually appointed as an executor.
Challenging as an executor, because somebody is appointed as an executor doesn't give them the right to challenge, right? Because will is very clear that the beneficiary is not the executor. They may challenge on different grounds. Not because of the fact that they're an executor, they may challenge saying that the will is not correct. It is a forged document. The person who wrote the will was not of sound mind and so on and so forth, right? That's how they'll challenge the will, not because you're an executor and you're not been given benefits. That's not a valid ground to even challenge.
Okay. All right. Thank you.
Going back to the whole thing of how to make a robust will, especially the fact of challenging, etc., that we spoke about, this becomes a good to have fact pattern to make your will another level, robust, right? Or more comprehensive to withstand any challenge. The matter of the fact that can you stop someone from challenging the will? The answer is no, you can't. But if the will gets challenged, can you come out of it quickly is where these things will help you out with. Things like having a video recording. Basically, you can read out your entire will in front of a camera. Take your phone, cell phone. You don't need to have any professional setup here. Just read out the entire document. Even if you make mistakes, continue. Don't cut the video and stitch it together. That doesn't hold as a good evidence. Take it as a one single video take. In that same thing, if you can able to also get your witnesses to sign, you sign the document, that becomes a very good evidence to prove before the court that if somebody were to challenge saying that you didn't do this out of your own will, you were forced to do this, or this is not the right document. If the document and this kind of syncs together in terms of the content, it becomes a legally valid document, and multiple Supreme Court rulings in the past have upheld this as a good evidence. Second, have a doctor certificate. Ideally on the date of, I would always recommend on the date of signing the will, because this will also hold tomorrow in situations where somebody were to contest on the fact that person was not of sound mind. So having a doctor certificate saying that you're physically and mentally sound will help kind of rebut those contestments. Third, we spoke about registration in the beginning itself. Having a registration also helps in, kind of making the will a little bit more authentic by the fact that government is also a third witness to your will. Obviously, the other aspects I can ignore for now. And these are things which will help you in contestment as well. We can open up the questions floor for others who have questions here.
Nikhil, thanks a lot for taking this session. My questions were actually from an immovable property, because I mean the movable property you can nominate and go through that. what happens in case of change in immovable property? Like in Mumbai, there are quite a lot of redevelopment is happening. So do I need to kind of change when again the redeveloped property come in? And what happens in between during the redevelopment? How does that happen? And what is the benefit of registration? Because in one of the society meetings, what committee members had mentioned that as a nominee, the flat can be transferred in the name of the nominee, but they will not allow the sale if the will is not registered and probated. So just if you can kind of elaborate on that particular aspect.
The same logic, that we spoke about earlier, right? See, it's a very peculiar situation for Mumbai because Mumbai has societies where shares are being held for the properties compared to actually the property being registered in your name. And that's why the nomination actually happens in Mumbai for the real estate. Otherwise, it's not so common, right? So when you nominate, again, the same logic that nominee can receive the asset. Nobody can stop from receiving. The nominee becomes the holder of the assets or the custodian of the asset, but not a legal heir. And that's why during transfer, they will still need, either documentation from the court or the registered will to make sure that they are the legal heir to the property. So that's the core logic here. With respect to probate, was mandatory. Now there's a clear law to say that that's also optional. It's not required. Right now, coming back to the point of saying, what happens to redeveloped property? What happens to, in interim period where the redevelopment is happening? You will also have an undivided share in the land, right? And that undivided share is yours. So when you say, this is my property, this is where I had, tomorrow if there's a real issue also there, you can still go back and say, this is the property that I'm talking about, right? And that should not be an issue because it's already covered. End of the day, you have a history to it. The point of saying amend the document, etc., will all come into the picture when you're selling this and buying a new property. Hope that clarifies.
Yeah. Thank you.
Dr. Rajneesh, can you ask your question?
Yeah. Hi, Nikhil. So,
yes, sir.
First of all, I have prepared my will through this chat GPT and I want to make it very simple. First of all, this documentation, no list of properties or movable or immovable assets, but I want to 100% to my spouse if we both live, and in case some mishappening happens to my wife or accident, some happens to I have two kids, so it will be equally distributed to my kids as well. So I want to make it simple, just simple. Yeah. And executor to my son and witnesses to my family members. So that's the thing. So you just guide me for making the most simplified procedure, easiest and simplified. Because
I really can't advise you.
Because for the last, yeah.
Sorry, I'm interjecting here. I really can't advise you without knowing what. See, you can use ChatGPT or any other, AI tools, but output we don't know. What is being language captured there? How is it captured? Becomes very tricky, right?
Yeah.
I usually would not. You can use it as a reference, but if you're using ChatGPT, etc., do it, but still have somebody read it through and saying that's kosher, right? Unless you know law. Unless you know exactly what the documentation is. Again, law is not needed, right? As long as you think it's very clear, it's okay.
Yeah.
Right? But I would not recommend going that path, right? One, that becomes a very critical. More importantly, nobody's advising you, right? You're capturing it basis what you want. And these are tools that may not really help you, give you real advice in terms of what is needed. Now, that being said, even if you want to make the simplest of the will, don't keep it as like a one-pager because list of assets becomes very critical unless you want to do it this fashion and give the list of assets to your family. Because many times families won't have details of the assets and therefore even having a will, they will not know what to chase and how to chase.
Right. Okay. Thank you.
Yes, hi, thank you. So my question is regarding either end, immovable or movable assets, which are situated in more than one country. So question is, can these be covered in a single will, or is it required, or is it legally valid to make multiple wills?
Theoretically, one will is good enough for any country, if assets in multiple countries, right? Let's look at two scenarios again. assets in multiple cities or states in India, one will is good enough. You don't need to do anything else. But when it comes to assets in multi-jurisdictions, when I say multiple countries, in that case, theoretically, one will is good enough, but I would not recommend that. It's better to have separate wills in every jurisdiction because your implementation formalities change depending on where your will is done. For instance, if you have a will in the US and you want to give it effect to India, India will say, first probate this will or prove this will in the courts of US. Once that is done, they'll say again prove it in the Indian courts, and thereafter is where you can do the transfer. But instead, if you had two separate wills, one in the US, one in India, both will would have run parallelly, and your family will save cost and time, right, before they recover the assets. So therefore, I would recommend that.
Very good. And the legal validity of having two wills, are they simultaneously?
Absolutely valid. Absolutely valid. It again depends on how you write the will, right? You need to clearly say this is pertaining to India assets only, and the overseas will should not override this will. So the language has to be very clear, saying that how you crafting it. That's where things become very critical.
Okay, thank you so much.
Anurag, could you ask your question?
Yeah, thanks. So, couple of questions, Nikhil. First of all, regarding the role of the executor. Now, in context of the fact that if I've defined a nominee for each asset that I want to pass on, and the nominee therefore is legally empowered to take possession of that asset and obligated to transmit that asset as per my will, what do I need the executor for?
So,
because the nominee is doing all the work.
So not all your assets will be dealt with nomination, right? There'll be certain assets where it will be there, right? Where you will need to come in. Now let's also look at a situation of, say, what if your will is getting contested? It's all great, right? It's all happening smooth. Tomorrow, if somebody is contesting, who is going to file the papers and other things on your behalf? So for many reasons, it's important. Now the role, whether the executor role actually is given effect to, in your case, if you say if all my assets are covered by nomination, Nikhil, and therefore I don't think the executor need to come into the picture, what's the harm in having an executor? The role doesn't come in, but tomorrow if there's a reason for it to come in, people do need to go to court. You can take care of it with the nominee, with the executor there, right? Again, you don't need a professional to be an executor. Who is your beneficiary? Why don't that beneficiary be an executor? That's a simple way to address this, right?
Okay. And my second question was, you mentioned some nice to have with respect to, doctor certificate and videography, etc. Now, correct. I'm a customer of yours. I've been making the will through your platform for the last 2 years. Great. The will that you have on the platform, I assume, is legally vetted for comprehensiveness.
100%, yes.
But that does not give these two options. So does
your
that
mail has it.
make that format legally a little weaker, or is it that nice to have really, if it is not there, doesn't make a difference?
It's part of your communication. If you have not seen your email, in the email, this will be part of the instruction kit, that these are things that you could do, including a link to say how to do the video recording would have come your way.
Okay, but that does not pop up when I'm actually filling up your will format.
No, it doesn't. It doesn't. It's part of the delivery, right? Once you generate the will, it comes to your email. In the email, you'll have all these instructions.
So let me simplify my question. What if I haven't done it? Am I likely to leave a will which is weaker legally, or it doesn't make that much of a difference?
No, not at all. Not at all, right? Now, if you have signed your will along with 2 witnesses, it's a legally valid document. Now, the way you look at it is, if Nikhil has written a will and, Nikhil says all the assets goes to a spouse, but say, for instance, Anisha wants to contest my will. Now, Anisha has to prove that Nikhil's will is not legally valid. Right? For Anisha to prove, there should be some evidence, and you'll also have even enough evidences, right? You'll have your witnesses, you'll have everything else in place. These are additional items to make it even more robust. What case could have gone for, say, 3 years, you're able to close it out in 1 year. That's the whole benefit here.
Okay, got it. Thank you.
Anshul?
Nikhil,
you were asked, I think, no?
Yeah, what I was mentioning was, you had mentioned that it doesn't need to be registered. So if it is not registered, will that be a handwritten with the person who has written that will, or how that would be?
You can have a handwritten will, you can have a typed will, which is signed by you. Both are legally valid. Right?
Okay.
Registration, like I said, is optional. It's not mandatory.
Optional. Yeah, but it has a benefit.
It has a benefit to it.
Okay. Thank you. Thanks a lot, Nick.
Perfect.
Back to you.
Many wills I have seen in my professional career. 50-60% are not registered.
I'm not very clear in terms of what you're saying, sir. The audio is not very clear. I'm not sure if it's
Well,
only with me.
registration is not a criteria. Will by hand with two witnesses is enough to get the assets transferred to the legal heirs.
Sir, I heard registration is not mandatory criteria.
Yeah.
Beyond that, your voice is muffled, sir. I couldn't understand.
The registration is not required at all.
It's not required. It's not mandatory. Right? That's very clear from law.
Okay. Fine.
Hi, Nikhil. This is Ruben. I had this quick question. Can you hear me?
Yeah.
Okay. So this particular will, does it give more weightage if somebody handwrites it? I mean, from his own hand. And secondly, the identification of the executor or beneficiaries named, should it preferably be uniquely identified by, say, an Aadhaar card or so? Because, for example, you have Ajay Patil. Which Ajay Patil are you referring to? So those are the two questions that I had in mind. Please.
No, great questions. Whether is it better to have a handwritten versus a printed will? Technically speaking, handwritten is even more robust, because if tomorrow somebody were to contest, you also have handwriting as a good proof to showcase, right? That this person has written it, and handwriting becomes another evidence. Same thing gets established with the signature as well. So it just adds on, but not so substantially, right? Now, with respect to identifying the beneficiaries with proofs, always good, right? Now, the ideal way I would have written the will is to say, also talk about who this beneficiary is by relation. My spouse as XYZ, along with the PAN or Aadhaar, whatever it is, right? I would go that full length, say, because tomorrow if there's any changes, whatever it is, you know the relationship to whom you wanted to give this, and the name is matching there. Plus the ID proofs if you add on, nothing like it. The simple advice that I give to everyone, right? You can keep it as minimal as possible, but the more information you provide, the better it is always. But you don't need to go to the information of saying values of the assets not required, only identifications.
Great. Thank you.
Nikhil, there is one very important question which I feel is good for the complete community here. And it is from Lalit, and it says, is there any issue with transferring money from parents to child or vice versa through the bank during their lifetime? And Anisha said there should be a case study also.
No, so, do you want to, can they transfer the assets during lifetime?
I think the question really is it better to just transfer within their lifetime all assets versus create a will?
I'm sure all of you have heard of Vijaypat Singhania Raymond family. So this is a case where, he transferred all his assets to his son Gautam. Now today there's court battle saying that my lifestyle is not taken care of. Please return the money back, which won't happen, right? But the case is going on. The point here is that, can you gift it? Answer is yes. But after gifting, what happens? Your immediate reaction to me is that it's my bloodline that I'm giving. Why would this really happen? But when money comes onto the table, things change. And that's a matter of fact. I've seen many such cases happen. And therefore, be extremely careful or cautious here, right? Definitely, can you gift? Yes. It's a very simple way to transfer assets, no complications after you're gone. But if there are assets after you do this and you need to be dependent on the other person, that's not a good scenario to have.
Okay.
So usual recommendation is that maybe a small portion can be gifted during a lifetime, and the balance, let it go through your will.
Yeah, thank you, Swati, for giving me a chance. Yeah, some of the questions I think already answered, but one thing is after the executor, you have mentioned a guardian. Who exactly and what is the role of the guardian, and who we can nominate as a guardian?
And one more thing, the executor, you said we should keep a backup, and if preferably somebody from the family or the beneficiary. So can it be all of the beneficiaries can be kept as an executor?
Yeah.
And the last question, sorry, quickly, the last question.
No problem.
When we say that we can keep changing the will, do we really need to, scrap initial one, or we can just add on as a supplement, or we can just revise it with some other document, another document? And a format, you mentioned a lot of things to be included, which I had already I thought would be ideal, but I believe there is no fixed format as such when we make the will, right? Begin from here and have this as the body, and of course the witness will be the last page, obviously. Yeah, that's all from me. If you could answer these, thank you.
Correct. I'll go one by one. First question was in terms of,
guardian.
My bad. Guardian. Yeah. So guardian essentially is for minor children, right? And even technically, even for specially abled family members as well. Now, the role of a guardian is basically, say, if you look at a minor children. Specifically, I just skipped it in this case because I'm presuming here anyone wouldn't have a minor child. If you do, then that's a situation that needs to be addressed here, right? Because parents are natural guardians for the child, right? And therefore, should something happen to one parent, the other parent is anyways a guardian. But God forbid, if both parents have passed away, then who should be the guardian to the child, right? And that nomination can happen through your will, wherein you can say so-and-so person is the custodian, or who will have custody of the child or minor child, is where the role of a guardian comes in. There also it's good to have a backup to say that if I were to say tomorrow my sibling is a guardian to my child, then what if my sibling is not there? Then who else should be? It's good to have that backup. Now, coming to the executor point that you mentioned, question that you had is that you should have an executor that can be a family member. Can you have backup, and can all the beneficiaries be a executor? The answer is yes. What I would not recommend you to do is that have everybody as a joint executor. Becomes extremely painful just for the whole everyone to come along, be together, get things done. Better to have a sequence. Ideally give, unless this your facts require something different. Otherwise, ideally, I would recommend have one executor at one point in time. But you can have any number of backups. You can have 2, 3. At least I'll recommend have at least minimum 1 backup. But you can have even 10 backups. Doesn't matter. It's absolutely fine. And the last point is on. If you could repeat the last question.
That was the will itself. If we have to revise or change the will, can we just add as a supplement or something?
So there are 2 ways you can revise your will, right? One is to, like you rightly said, scrap the entire previous will. Because if you write a new will saying that all my previous wills are, revoked, and this is the only will that you need to consider, all the previous wills are revoked. The other option is that you can also have a codicil.
I'm in a meeting right now.
Codicil is like an addendum to your will, saying that, say, for instance, let's give an example, right? I have an asset A which goes to spouse, but I want to change the wish to say asset A goes to child. So I can have a codicil to say that my will remains as is. Only this particular change I need to make in the document. That can be addressed through a codicil. But I've seen situations where this is a live case of one of my clients, right? Where he has about 5 codicils, saying that codicil 1 made a change, codicil 2 changed the main will, codicil 3 changed the first codicil to whatnot. Now everybody needs to have the entire 5 codicils along the will to completely give an effect. If one of it is missing, then you have an issue. In that cases, it becomes important that you kind of scrap everything else, write a fresh will with all your changes so that it becomes easy for the family to take care of it thereafter.
Thank you very much. Thank you very much, Nikhil. Much well clear.
Yeah.
Pranav, please go ahead.
Yeah, hi Nikhil. Nikhil, just wanted to get one clarity because I have heard that in case of a will, all the legal here just get around 75 to 80% of the amount. Instead of doing that, one should create a trust and transfer the entire property to that. So just wanted to understand the logic behind it and what would you recommend in this second?
I'm not sure where this 75 to 80% is coming in, but that's incorrect, very honestly. Now, the reason that could have come in could be a logic of saying you're missing out on certain assets. Family is not aware of it. And therefore, you end up missing out those assets. Could be the logic, but not otherwise, right? Just because you have a will doesn't mean that you lose 25-30% of your asset. It doesn't happen, right? Now, you could also be talking about this. I'm trying to see where is this coming or where is this stemming from, right? This logic could also be stemming from the fact that potential estate duty or inheritance tax loss. In that cases, obviously, before assets move to your family, the assets, assets, before the family gains access to it, government will charge a tax to it, which is applicable in the US, UK, and other jurisdictions, which is at 40% today, right? So therefore, the tax has to be first paid, and then the family receives the assets from the demised person. So to plan for this, in those cases, trust really helps, right? India doesn't have an estate duty law or inheritance tax law right now. It did have it in the 80s. It got abolished. At that point, the peak estate duty law rate was also 85%, right? Today, there's nothing on those lines in the legislation today. But is there something on the cards? It's always a conversation that keeps happening before budget every year. That being said, if it gets introduced, then yes, a trust becomes a good vehicle to kind of plan for it. But the bigger point here is that if I create a trust today, do you think it's 100% proven that this will, kind of take care of it from a estate duty perspective in India? The answer is no. We don't know. We need to see how the law gets enforced and see if this is actually taking care of those scenarios, right? But the ideal way to go about doing it, because we do help clients get their trust, etc., done. The ideal way to go about is keep the thing, the whole document flexible to make edits as and when needed, so that when the law comes in, you kind of ensure that we can fit into the scheme of things to see if it's still effective or not, right? But beyond that, since I did touch upon we're talking about trust. A trust really helps if your wishes are much more complex than what can be achieved through your will. Simple examples like, tomorrow, if you have minor children as an example, and you don't want these assets to go to them at the age of 18 or even 25, but you want to defer it. In that case, a trust helps, because through a will, you can't do it. It has to go to them. But in a trust, you can define to say that until then, their lifestyle, education is taken care of, but they get access to the assets only after they turn a certain age. If you want to protect yourself from a potential liability, from separation-related payouts, etc., a trust becomes extremely efficient from a planning standpoint. So those are reasons when you look at trust beyond a will. I know I kind of went beyond, but I really don't know where that 30% was coming in, so I'm trying to address all scenarios possible.
No, thank you. Thank you very much. It was really helpful.
Sashri, can you go ahead?
Nikhil, my question to you is, what if the nominee doesn't pass on the assets part to the legal heirs, number one? Or is there any other way to protect this, to ensure that the legal heirs get their become the ultimate beneficiary at the end?
So it's very simple if you ask me, right? Unless your family situation is much more complex. If you're saying assets are going to 2 or 3 people, today in your bank and demat account, you can have nomination for multiple people. Correct. It's not only one person. And have your will kind of, align with your nomination. So today, if you say you have 2 children, both assets need to go equally to both children, make 50-50 nominee for the 2 children. And in your will also say these assets will go to your children 50-50%. It's very clear. There's no dispute. Both are getting their 50% share, and will is also saying as is, right? So therefore, it takes care of this.
But what about the non-movable properties?
For immovable assets, unfortunately, you can't do anything much, right? But their nomination also you can't have. Right? In places like Bombay, etc., you can have nomination, but other locations, so say if you're in Karnataka, Chennai, and whatnot, there's no nomination possibility at all. In that case, your will only has to come in, and registered will take care of it.
Okay. Thank you.
Yeah, Sashikala, would you like to ask your question?
Yeah, sure. Am I audible?
Yes.
Yes.
So Nikhil, my question is a little personal, in the sense like more to do with law probably. Like if I'm single, like I don't have any dependents, don't have parents, don't have child, don't have husband, then as you know, legal, any will cause so many repercussions, because they don't know in our old age who will come, who will stand up to take care of us. We really don't know the future. We have siblings and other, close siblings. So what is like default? I mean, I'm saying, let's say there is no will, what happens?
Goes by the Indian succession law, right? Like I said, it's a long list if you ask me. First, there's something called as Class A beneficiary and Class 2 beneficiary, right? Class 1 is essentially first for I'm presuming you follow Hinduism. In that case, it's spouse and children is a first class, right? As in first level, which is not there. Then it goes to parents. If parents are not there, then it goes to siblings.
Okay. So all siblings are equally eligible.
Yeah, equally eligible. But again, they need to prove, right? It's good to still have a will in place to kind of provide this. In your case specifically, I think, if you think there is a situation that in old age you need to also have some sort of a protection in case of incapacity, etc. A trust could be a good option that you should also explore if it makes sense.
I see. Okay, so the trust will sort of hold it until it is passed
until
on.
you are there, your medical bills are taken care of, because your assets, if should something like an incapacity hit you, it will be frozen. You can't use it for your medical benefits, and you can't even sign anything, right? Both it becomes a catch-22 situation. So therefore, having a trust will ensure that your siblings, etc., can take charge and help take care of your medical situations.
And absolutely no information should go on as to what I'm really intending to do right till the end of my life. That's how I want to keep it.
You can have, if your wishes are to say go beyond siblings, you want to give it for charity, etc., all of those can be done either through the trust, through will. Both situations are possible.
But it's important to have a will created, registered, and then
100%. 100%.
Okay, thank you so much.
Hi Nikhil, can you hear me?
I can hear you.
Yeah. Nikhil, I have one simple question. Suppose we are making a will. In the will itself, we are writing if any addition or subtraction to the details given of property or mutual funds, shares, gold, or whatever is there. And it is applicable at the time of my demise, whatever happened, whatever is there, that will be divided by 50-50 within two beneficiaries. So in that case, do we need to amend the will at any time? Because when maybe I'll buy a property today, I will sell it tomorrow, and after some time I'll buy something else. Like this, it keeps on going like this. But if we put a simple word in the will saying that any addition or subtraction, that will be applicable at the time. So in that case, do we need to keep on amending the will? Is it required?
You don't need to. Technically, no. But when it comes to real estate, if you're changing too much on the real estate, better to have it amended. If you're doing it on a movable asset, I'm absolutely fine. As long as your residuary asset, right, saying that any future assets you're giving a direction, it should work, right? But see, let's start off this way, right? You started with, assets A to B, A to say 1 to 10, let's put it this way, right? But end of the day, 5 out of those assets are remaining, and you added 10 more other assets.
Yeah.
This is not a good scenario to keep. You might as well update your will. But say you had 1 to 10 assets, you changed 2, probably added 1 more. It's okay. You don't need to do any change. Continue with your will. You also need to take it like there's no thumb rule here, right? If there's a substantial change, it's always better to do this.
All right. Okay. Thank you. Clear. Thank you.
Yeah, absolutely. Sure. Hi, Nikhil.
Hi.
Basically, hi. So I just wanted to have some clarification. So in some other wills of other jurisdiction, for me, when I came across this will in Australia, so they have this concept of named and unnamed beneficiaries, especially for blended families, for example, and they want to have want their assets to flow in through the lineal descendants. Now, so I just wanted to ask whether that is something, with regards to the Indian succession laws that are there presently in will, if the testator wants their assets to flow through the lineal descendants, can this be like, how would you want this to be done? Maybe through appointing the executors. And for example, I have 2 children, and I have made them the executors, and I want the assets to flow through the lineal descendants of the executors, and not go into maybe their children's wives, etc., and keep it bloodline specific. So is that something that is considered, or is there options to make sure that this is something that can be legally incorporated into the will? So yeah, that's all.
Sure. No, so let me understand your question better, right? So if your question is to say that, today I have 2 people as an example, 2 as a beneficiary, and probably we may have an unborn child soon, right? So I
Right.
don't know. Therefore, I want to name everyone. You can have that open-ended, right? To say all my children equally. That's good enough, right? Which will take care of it. But if your question is to say that, I'm giving it to my children and ensure that these assets pass on from my children to my grandchildren and can't go anywhere else, you can't. You can't have a conditional transfer through your will. You can either do a transfer and it continues. If you want to do any conditional transfers, then you need to have a trust. Wherein you can say the assets will be, who can continue to benefit from this trust is something that you can clearly define. It's
Right.
bloodline, non-bloodline, and all of that.
So through like a family trust, that's possible.
Correct.
Okay. Thank you so much. Yeah.
Good. Nikhil, I have two questions. One is witnesses can be from the family only, or can be taken out. Family is okay. Or second thing is, if I write the will where I write only the bank saving account number, the FD also will be considered in the same section, or I have to write the FD name also, FD numbers also. That is all two questions.
So with respect to FDs and savings account, you can if your FD is linked to the savings account, typically what happens is that after the maturity, the money comes back to the savings account, right? So you can just say the savings account, and you can have a language below that, right? Saying any investments. You could also have mutual funds invested through a savings account. You can have a language to say all the associated investments under this link to this bank account should go to the same beneficiary. You can give that effect. It doesn't matter, right? Now, do you want to list your FD? It helps. But the moment you at least give your bank account, right? Typically what happens is the moment you reach the bank and try to claim, bank usually does a complete check to say what other relationship that you have with the bank. So you have a savings account, they'll try and say, okay, you had a FD, you had a current account, you had whatnot. They try and put together everything for you. That happens, right? Sorry, your first question.
Witness can be from family member.
Witness can be family, but not beneficiary.
Okay.
Right. So if you're saying spouse is the beneficiary, your spouse should not be the witness.
Okay. Thank you.
Nikhil has been kind enough to stay for 25 minutes. So I'm going to take one last question from Lalit, and I request the others to put your questions down in the chat, which if we can answer, we will try. If not, I will answer them post the session, because I think Nikhil will be kind enough to help me to do that. So Lalit, if you can go ahead with the last question.
Yeah. Hi, Nikhil. So anything which is given during the lifetime, it would be termed as a gift, right?
Correct.
Now, when you are giving gifts, so maybe a money transfer, right? Say maybe for your child's education and things like that. So if it is happening through a bank, so is that transaction itself good enough, or should there be some gift deed or something like that? And also, if the child starts earning and he or she wants to return the money or give it back to their parents, so is there any issues with that, or there should be some procedural things which should be taken care of?
So honestly speaking, if all of this is happening in India, you don't need to do anything, right? You can give freely, you can receive gift from your kids. All of it is absolutely fine. No issues. But the reason I said is, if in India, it's okay. But if the moment one of the family members are outside of India, we should also look at the implication in that jurisdiction. Simple example, I'll give you one so that you get a perspective, is that if you're in the US, gifting in the US is taxable, even if you give it to your parents or if you give it to your child. Right? If you're a US citizen, you want to start gifting assets, then you need to be careful saying how much you can give. There is a limit. If you go beyond those limits, you'll be taxable. So those are things that you need to be mindful of. Otherwise, if it's all in India, everybody Indian residents, citizens, no issues, gift how much ever you want and take it back as well. No, absolutely no problem.
Gift deed is not necessary from income tax point of view.
Income tax also, it's absolutely fine, right? Tomorrow, if somebody were to question it, see, you can have a gift declaration kept in place. Now, it all depends on the frequency, number of transactions, and so on and so forth, right? Now, if tomorrow there's a question coming in, you can always say this is transferred to my child, which is absolutely fine.
And it could be frequent.
It can be frequent, no issues.
And not to get a registration or anything of that sort, just a simple paper would do.
Absolutely fine.
Great. Thank you.
Swati, just one small question. I have last question, Nikhil. When you, as you rightly said, writing the will by the own handwriting is very good, but sometimes you make some mistake in writing. Okay, and suppose you overwrite, or what is a legal way to overcome that? I mean, because with a long will, you may tend to have some mistakes, somewhere. So, what one should do? What care one should take?
Yeah, so ideal scenario is not have edits, right? If you're having edits, have a signature there as well. Typical way you go about. And that's one other reason, right? See, if you're writing a one-pager will saying no, all assets goes to spouse, etc., then a handwritten will make sense. But typically, even if I were to generate something through our platform, etc., I don't see wills being anything less than 8-9 pages.
Right.
Right, minimum. So is it okay for you to sit and write all of it? Then it's fine. It's a good way to go about it. But, you can still have a paper document, sign in all pages.
Okay.
If your concern is about that, you can...
Yeah.
Your always recommendation is you sign in every page.
Correct.
So that the will is legally valid.
Yeah. That's okay. Yeah, fine. And our one question. Normally, we have a lot of property which is big family, we have land and home and all those things are there, where I am one of the person out of 10 persons. So in that case, for my wife and my son, what is the way of delegation? Suppose, because still it is not on my name fully. Okay, the property is in a combined family. In that case, what is the way to go about? I mean, can I write this in a will that this is my property, this is my 7/12, survey number and all those things are there.
Yes.
And this is my total property, of which whatever I am eligible, now that inherits or that goes to my heirs. Something like that can be written like that?
That's correct. You can do that. You can basically say my share in the property, if it's jointly held between family members, my share will be dealt in so-and-so fashion, and then that's good enough.
Okay.
Ideal scenario is that if possible, you should look at, partitioning it and closing it down.
Yeah. Okay. Yeah. But that may not be so easy.
Thank you.
Yeah. Thank you. Thank you, Swati.
Thank you. Thank you, everyone, for being here today. I just cannot ask Nikhil to stay any longer. I have been very unfair. I have taken 30 minutes more of his time. So I want to thank you, Nikhil, for being here and for answering all the questions that everyone had. I know this is a very important topic, and we probably will have you back again another time to take care of all the queries that everybody has. But thank you all for joining, and please reach out to me if you have any questions, and I think Yellow will be able to answer the questions for you. Thank you, everyone.
Thank you. Thanks so much for having me on this session, and hope there's some value to everyone. Right?
Thank you, Swati. Thank you.
Thank you, Nikhil.
Have a great day. Have a great evening. Thank you.
Great.
Thank you, everyone.